these kind of issues have become extremely important now with the climate change legislation and climate change rules and regulations that are coming out on a daily, hourly, or every minute or so basis from the alphabet agencies. Because when science is being litigated, uh, I would say it would be difficult for judges and lawyers necessarily to have enough knowledge to make decisions about scientific issues. So the Chevron decision, doesn't that make it easier for courts to rely on outside uh, scientific opinion? And isn't there also a principle, I believe, called the Daubert principle, by which courts, it is possible to litigate the science prior to making decisions? Isn't that also not something that can be used in these cases?
The Daubert principle is a principle that governs the admissibility of certain scientific evidence. Now, this all takes place at the trial court level. So there are district judges at the federal level, and there are trial judges at the state level that are concerned with what evidence is admissible, how valid is the scientific judgment underlying that evidence, and they will apply the Daubert principle to get rid of evidence that does not qualify as scientifically valid. However, once the case moves to the appellate level, and most particularly to the Supreme Court, U.S. Supreme Court level, factual matters are supposed to have been settled. And it's up to the court then to exercise its judgment regarding legal principles. Now, it is true that if the lower courts have been clearly erroneous in their assessment of factual matters, if there's been a clear error in that regard, the appellate court will step in, but it's very rare. Usually, the appellate court will confine itself to legal issues and leave the fact finding up to the lower courts. The lower courts will be guided by and will enforce the Daubert doctrine on admissibility of evidence.